No be work. Done ready.
Good afternoon, everyone. How are you doing?
We're fine, thank you, ma. Good afternoon, ma.
Very fine, thank you, ma.
Okay, good afternoon, everyone. I think we've given extra time for those who are taking their time to join the meeting or the class. We will start now. I hope you can hear me.
Very loud and clear, ma.
Beautiful. Thank you. And so in today's class, we will discuss terms of contract. Initially, we talked about um, how to form a contract, offer the elements of a valid contract, which are offer, acceptance, consideration, and intention to contract. We even during the introduction, we talked about the different types of contracts. We had, a brief discussion on the types of law and the fact that contract law is more of a type, the business type of law is private, it's civil, and it just regulates or governs the transaction between parties. And so in this class, we're going to be talking about the content of the contract. Because if you remember, we've been talking about the forms of contracts. How are those contracts formed? What are the elements of those contracts? But today, we are going to be discussing the content of a contract. And so when we talk about the content of a contract, it's basically about the terms and the conditions of the contract. During negotiation, different things are said. Parties say different things, right? They make different promises. And, some of those statements, they make different statements. Some of those statements or those promises that they make or they made during the formation, during negotiation, some of them would eventually be considered as part of the contract. And so those terms that I considered part of the contract are referred to as terms. Someone's audio is on. Can you mute yourself? Rodia. Yes, I can see someone's hand. It's not read the class. Do you have a question or something?
No, it was a mistake, ma.
Okay, that's fine. So not all terms, not all statements, not all promises that are made during negotiation are considered part of the contract. Some of those terms are simply referred to as, some of those statements, not terms, some of those statements are simply referred to as, as representation, as mere representation. Just a minute, I'm trying to remove something from my screen.
Sorry, ma. Also, it seems like the audio is sounding a bit muffled. Boy, or hearing shot.
Okay. Is it just for you or for everyone? It could be my earpiece. If it's my earpiece, I can take it out.
It's for everyone.
For
I
everyone,
think
ma.
It's for everyone. Okay, maybe it's my earpiece. Let me take it out. Okay, is it clearer now?
super clear,
Yes,
ma.
it is.
Okay, that's fine. So I'll repeat myself, for the benefit of the fact that I've been talking since and it's not been very clear, but I'll do it very briefly. So I said that during negotiation, different things are said by the parties, that are trying to enter into a contract. But not everything that is said, not every promise or every statement that is made during negotiation will be considered invalid part of the contract. So there are certain statements that would be made, but that they wouldn't be taken very seriously, right? They won't be binding. They won't have any binding force, which means that if the other party tries to make the person who made the statement to perform that promise, or the promise that the person made, or to keep to their word, and the court finds that that statement is not a contractual term, the court would not enforce it, or the person will not even get any serious remedy. So, as I said, different promises are made, different statements are made. Some of those statements come with binding force. Some of those statements are legally binding, which means that if one of the parties does not do what it is that they made the promise to do, then the other party can enforce the contract. However, some of those statements do not have legal force. They can't be, the other party cannot be found, legally liable to perform that under contract law. It doesn't mean that the other party might not be able to rely on other types of contracts, on other types of, laws to be able to enforce that promise. For instance, if it's a fraudulent, if the promise was made with the intention to defraud the other party, you might not be able to enforce it under contract law, but you should be able to, use criminal law to seek remedy, or to get the person arrested. You might even be able to use the law of torts, which is a different type of law. It's very similar to contract law because they are all common law based, but it's not contract law. It doesn't have to do with transactions. So aside from contract law, there are other remedies that the party can rely on. But with respect to contract law, which is the focus of our class, a statement that is not legally binding, a statement that does not that does not form part of the contract would not be considered, a contractual term. So, in other words, contractual terms are those terms that are legally binding, whereas the terms that are not legally binding are considered mere representations. The terms that are legally binding are considered to be terms. The statements that are legally binding are terms. They are referred to as terms. I'm sure you've heard terms and conditions, although it's not exactly, it's a little confusing because you would eventually learn that conditions mean something, right? But it's what those things, what that document that you see that has terms and conditions is probably saying is that these are the terms of the contract. These are the statements and the promises that are legally binding on the parties. So that those are the terms and conditions, but then what is important for you to know at this point is that statements are made during negotiations. Some of those statements are legally binding, some are not legally binding. The ones that are legally binding are referred to as terms. The ones that are not legally binding are referred to as mere representations. So it's important now to determine, to at least to understand, to have an understanding of how the courts determine which of those statements are terms and which of the statements are mere representations. Because most times you'll find that parties have different understanding of what they thought were the terms in the contract. So one party might think that that statement that you made, that the hall, let's say there is a contract to hire a hall, and one of the parties has promised during negotiation, trying to encourage the other party or to sway the other party to enter into the contract. One of the parties has promised, you see this hall is has 5,000 capacity. This hall has AC, that can cool, that cools the place very well. It has good functioning toilets. It even has sound system that works perfectly, and that person is making all those promises. Some of those statements that person has made, would be considered terms. Some of the statements that person has made might not be considered terms, but might be considered mere representations, depending on several circumstances. So what are the circumstances or the factors that the courts usually use in determining whether a statement should be considered a term or a mere representation? That is what is listed right here on the screen from 1 to 4. So it's important that I state now that these tests, right, they are not absolute, they are not cast in stone, which means that, just because a contractual term seems to fall into one of them doesn't mean that it must, apply, that the court must use these rules. So these rules are more like guidelines. I won't call them rules, they are tests. They are more like guidelines that helps the court to determine whether to classify a statement as a term or a mere representation. And so the first one there is the stage of the contract. At what stage of the contract was the statement made? Was it made at the early stage of the contract when the parties were still trying to get the other party to enter into the contract, or was it made at the later stage of the contract after the parties already know what it is that they want in the contract, in the transaction, and whether or not they even want to form a contract? And so the general rule, the rule there, right, is that most likely statements that were made at the early stage of negotiation, at the early stage of the contract, would most likely be referred to as mere representations, as representations. However, statements that were made later during negotiations or during contract formation would most likely be considered terms. The second rule or the second test is agreement reduced to writing. So what this simply tries to do, or what the court tries to do when it comes to this particular test, is that the court asks itself, the parties agreed on terms, and they probably agreed on those terms orally by words of mouth, right? Spoken words. And they agreed on those terms already, but eventually they decided, yes, we've agreed, these are the terms that will govern our contract, and they eventually go and put it in writing. So after they've put it in writing, the courts will usually consider those oral statements that did not find their way into the contract as mere representations. So if there are statements that were made orally, but were not eventually put in writing, the contract will consider that the courts would usually consider them as mere representations. But if there are statements that were made that, of course, found their way into the written contract,
they were made orally but eventually put in writing, the court will usually consider those statements as terms. Then the second one is special knowledge and skills. Special knowledge and skills. So usually, when a party can show that, when the party shows or the court understands or knows or sees that the party who made the statement in question has superior knowledge, has knowledge and skill with respect to the transaction, the subject matter of the transaction, then the court would most likely consider that statement made by the expert or by the person who has superior knowledge as terms, whereas the ones that were made by the non-experts would be considered as mere representations. Then the other one is the importance of the statement. If the statement in question was made by a party, and during the time the party made that statement, right, the other party who the statement was being made to informed the party who was making the statement that, you see, the statement you've made now is really important to me. If you hadn't made this statement, I would not have entered into this contract. So you see that by making that type of statement, by saying that, the party who the statement is being made to has already communicated to you the importance of that statement that you've made. And so when a party has communicated the importance of a particular statement, the court would usually consider the statement that was made as a term and not a mere representation. So let me give you an example. Let me start the example with this party with special knowledge, right? So there was a contract, there was a case where parties decided to enter into a contract to buy a motorcycle, a machine, a motorcycle. And, the party, there was even another one with respect to a car. So the party who was trying to sell the car, was a car dealer and knew all about cars, and stated that, you see, this car, it's a 1986 car, or it's an 1823 car. It has so mileage. These are the specifications. These are the things the car can do and what it can do. And the other party, who was just, a mere consumer, bought the car based on the statement that was made by the party who was selling, who was a car dealer, right? In such a case, the court held that the statement that was made by the car dealer was a term because that car dealer has superior knowledge about cars. If we swap or change the scenario, and the person who made the statement about the car mileage and the car, the things that the car can do, right? If the person who made the statement is someone who is just selling their old car, or who has decided to jabber and has decided to sell all of their property, right? And probably does not know anything about cars, so the statement might be considered as a mere representation and not a term. Another example with respect to the last test, which is the importance of the statement, is that there was a case where a party wanted to buy hops. Hops is like barley. People, they use it to make beer. So a party wanted to buy hops, and he informed the other party. He asked the other party, this hops that I want to buy, as I say, is like barley, right? Was it treated with sulfur? Because if it was treated with sulfur, I won't buy it. It won't be, it won't work the way I want it to work. It won't be able to ferment into a beer. And the party who made the statement said, oh no, it was not, the hops were not treated with sulfur. They are just regular hops. They were not treated with sulfur. You can buy it. And the other party informed him that it's really important to him that he buys hops that were not treated with sulfur. another party convinced him that, yeah, they were not treated with sulfur. And he went ahead and he bought the hops and found out that they were actually treated with sulfur. And, they were not good for what he wanted to use them for. And so he brought an action in court. And the question now was whether the statement that the hops were not treated with sulfur was a term or a mere representation. If it was a term, of course, the party who made this wrong statement will be held to have breached the contract, and, there'll be consequences for the breach. But if it's like a mere representation, of course, the party who made the statement might not be held liable for making that type of statement. But the court held that it was a term because the party who was at the receiving end of the promise or the statement stated clearly that you see this statement that you're making is really important to me. If it was treated with hops, I would not buy it. So by saying that, he was already clearly stating the importance of that statement. And that was why the court held that it was most likely, it was a term. So some people are trying to join the class, I see. Okay. I'm trying to admit them all. I just wish I had removed waiting room. So the next one is that contractual terms are categorized into three. There are three categories of contractual terms. Remember that so far we've talked about how the court decides, whether it's a statement that's been made is a term or a mere representation. So now we can now say that, okay, the court has decided that it's a term, or the parties are not disputing whether it's a term or a mere representation. They already agree that it's a term. The next question is the implication of each of those statements that have been made, the implication of each term. So terms are categorized into three: conditions, warranties, and innominate terms. Terms are classified into three: conditions, warranties, and innominate terms or intermediate terms. So what this simply means is that some terms are more important than the others, right? There are different, some terms are more important than the others. There are different categories of terms. There are different importance of those terms. So under the Sale of Goods Act, sales are basically categorized into conditions and warranties. Innominate terms eventually came into the scene based on the case of Kung Fu Hong Kong Fire Shipping Company. But then it's not important for you to know the case. All you need to know at this point is that terms are categorized into three: conditions, warranties, and intermediate or innominate terms. So what are conditions? Conditions are those terms that have great importance. They are the terms that constitute the main purpose of the contract. The terms that if a party fails to perform, it goes to the very root of the contract. That's the main aim of that contract, to perform that term, right? If a party breaches a condition, it entitles the other party, it entitles the innocent or the injured party to terminate or repudiate that contract. So what that means is that these are very important terms. Conditions, they are very important terms. That if a party does not perform a condition, it entitles the other party to go and say, I'm not doing anymore, give me back my money. And maybe even ask for damages on top of it, damages and monetary compensations. So, or even ask for damages, on top of saying, I don't want to enter into this contract anymore, give me back my money. So conditions, let me give you an example. Example is where a party, let's say Davido, was contracted to come and perform, during one of your hall or faculty events. So one of the contracts, in fact, the contract says that he would come for rehearsals, right? For 2 days rehearsals, and then he would perform on the 3rd day. But then he doesn't come for rehearsals, or even if he comes for rehearsals, but he doesn't perform on the 3rd day for one reason or the other. He doesn't perform, right? That is the breach of a very important statement. Not performing is a condition, because the primary aim of that contract is for him to come and perform, right? So if he breaches that contractual term by not coming at all, that is the breach of a condition. And it would entitle whoever contracted him to repudiate that contract, to terminate that contract and say, Davido, you didn't come to perform. You agreed to perform and we paid you for performance and you didn't come. So we are terminating the contract and we are asking you to give us back our money. And we are also asking for damages, because we have suffered a lot of loss by you not coming. We've already made expenses, we've already incurred expenses. So you need to compensate us for breaching your part of the agreement. Another example is if you try to enter into a contract to buy a car, and instead of a car being delivered, a bicycle is delivered or a keke is delivered. You can see that the main purpose of that contract is to buy a car, and not performing that contract, or even maybe they didn't even deliver anything at all, right? Or maybe they deliver something that was supposed to be a car but doesn't move. So you can see that the breach of such a term is very important, is a condition. So if you supply a keke instead of a car, that is the breach of the contract. And this breach goes to the very roots of the contract. So it's very important. And such a breach would entitle the innocent party to repudiate the contract and also to ask for damages if they so please. The next one is warranties. What are warranties? Warranties are the minor terms, right? The less important terms. The breach of a warranty would not entitle the innocent or the injured party to terminate the contract. The breach of a warranty would only allow that party to ask for damages. It's important that you know the difference. The breach of a condition would entitle the other party to terminate the contract and also ask for damages. The breach of a warranty would not entitle the other party to terminate the contract. Rather, it would only entitle that other party to ask for damages, because the courts would not try to, to be unfair, right? So if it's the breach of a term that money can cure, right? You can use money to remedy it. Then the court will definitely, expect that you use money, you pay damages to be able to compensate the other party and to remedy the defect. For instance, you ask for a car, a black car, but what was supplied to you is a white car. You see that it doesn't go to the root of the contract, because you can actually go take the car, or the party who breached the contract can take the car to a mechanic and have it repainted to the color that you want. It will only cost you money. If it was that you didn't supply a car at all, or you supplied a keke, or you supplied something else, right, that goes to the root of the contract, and the other party can terminate the contract. But if it's like a warranty, for instance, the color, or maybe whether the seats are leather, or whether the wheels are alloyed, you can see that those things can be remedied with money. So they are not usually considered very important, terms. So the consequence of that, of breaching a warranty, is that you can only ask for damages. You can't repudiate the contract based on the breach. Then the third one is innominate terms or intermediate terms. So these are like the hybrid. They sit between conditions, which are the important terms, and warranties, which are the least important terms. So the innominate terms are those ones that are somewhere in between. Most times the courts might not even be able to determine whether they are they should be classified as conditions or whether they should be classified as warranties. For instance, if I ask for a Toyota, right? If I ask for a car, a Toyota RAV4, and what is supplied to me is a Toyota Highlander, or even a Honda Civic, or a Honda CR-V, right? You would see that the court might find it difficult to just immediately say, well, that was the breach of a condition, or that was the breach of a warranty. So the fact that it's not very easy for the court to be able to classify that breach as either the breach of a condition or the breach of a warranty means that that breach would fall under what we refer to as innominate terms or intermediate terms. And what happens with innominate terms is that for the court to be able to decide whether to treat the breach of that contract as the breach of a condition or the breach of a warranty, the court would use what is referred to as the substantial benefit test. What is referred to as the substantial benefit test. This substantial benefit test, what it aims to do is to determine that by that breach, did it deprive that the breach, right? How serious was the breach to the party the innocent party? Did it deprive that innocent party of all the benefits that they should have enjoyed in that contract? Did it deprive the innocent party of all the benefits they should have enjoyed in the contract? If the answer is yes, then the court will treat that term as a condition and allow the innocent party to terminate the contract and to seek for damages. If the answer is no, then the court would treat that contract as a warranty and only entitle the innocent party to damages. So now we've talked about the different ways of categorizing contractual terms, the different categories. We say that there are 3 categories. The next thing we'll talk about is now the types of contractual terms. But before we talk about the type of contractual term, does anyone have any question? If you have a question, please raise your hand. Or even as we go on, if you have, okay, I can see your hand, Jennifer, but even as we go on, anyone that has a question should feel free to raise their hands and I will get to you. I can see your hand, Jennifer. Please go ahead with your question.
All right, ma'am. Good afternoon, ma'am.
Good afternoon, Jennifer.
Yes, ma'am. So, I have a question concerning the innominate terms. You said if the breach is very serious, then they will treat it as conditions. But then severity depends. So, if something is serious to me, it may not be serious to another person. So, how would they now be able to judge that severity? Because
Yes.
what's important to me may not be important to you. So even that color thing can be very, very important to me. I want all my house to be pink. I want all my cars to be pink or something. But then because my house say, it's just pink now, it's not that serious. I don't know if you get what I'm trying to ask.
Yes, I do. Thank you for that. And that's a great question. Yes, it's relative, right? It's subjective. What might be important to you might not be what's important to another person. So I agree with you. So what happens in certain scenarios is that the parties are free to include anything that they want in their contract. So the parties might even in their contract expressly state that, you see, this term is very important to me, right? And they put it there that this term is a condition. And the courts, would most likely agree with, with whatever it is that the parties have agreed, because the court does not the aim of the court is not to rewrite the contract for the parties, but to enforce the contract. But there are also cases where the court has decided that even though you both agree that this is a condition, it is not serious enough for us to consider it a condition. So I understand your question, right? In such a case where the courts, look at what has been considered to be a condition, the court might decide that it's not a condition simply because the court believes that money can mend it, money can buy it. So if it's for instance, you said you like pink and you want to make everything pink, good and fine. The court might ask itself, can this other party who breached the contract be made to pay extra money to be able to make it pink? For instance, if it's a car and you want it all pink, it's easy to repaint the car to pink, right? And if it's like a chair or the house paint or things like that you all want pink, it can be redone to be pink. However, that is also why we have innominate or intermediate terms. The court also recognizes that there are instances where it's not very cut and dry. It's not very clear whether the term should be considered a condition or a warranty, right? And so in such a case, the court would now classify it as an innominate term and apply the substantial benefit test. In other words, it will ask itself, this party, what was really important to this party when they entered into the contract, right? This pink that they kept saying, how important is it? If it is not the same pink that she wants, does it deprive her of the whole benefit, right? If it's that it's so important that it deprives her of the whole benefit, and it can't be cured with money, then the court will consider that, will treat it as a condition, even though it doesn't on the face of it look like a condition. I don't know if that answers your question, Jennifer.
Yes, my does. Thank you.
All right, I can see someone else's hand up. Did the person lower it? Okay, maybe it's been overtaken. Maybe it's been answered. Okay, so we'll just move on. So as we've talked about the various categories, of contractual terms. Now, it is also important for us to talk about the types of contractual terms. Terms are mostly of two types: express terms and implied terms. If you noticed, if you were listening at the early stage of our class, probably the first class that we had, you heard of express and implied contracts. The same applies with respect to terms. What this simply means is that for express terms, it simply means that these are terms that the parties agreed upon. They expressly, I don't want to use the word expressly because that's the express term again. They explicitly, let me use that one now. They explicitly or specifically agreed on those terms, either by writing or by words, oral. So the express terms are those terms that the parties explicitly agreed or specifically agreed upon, either by their words of mouth or written words. So these are the terms that the parties agreed on by words, right? Either either written words or oral, spoken words, right? And implied terms, on the other hand, are those terms that even they were not in words, they were not specifically agreed by the parties. The parties probably did not even discuss it at all. But these terms are terms that are read into the contract. Remember that when we talked about implied contracts, we talked about those contracts that are formed, mainly by the conduct of the parties. In this case, with respect to implied terms, these are terms that are deemed as part of the contract, even though the parties did not specifically agree upon them, even though the parties did not even discuss them or state them. They didn't agree upon them, but they are read into the contract due to, by the courts. So implied terms are also classified into three: terms implied by courts, terms implied by custom or usage, and terms implied by statutes. So implied terms, these are those terms that the parties did not agree upon, but they govern the contract because they were read into that contract, either by the courts or by custom and usage or by statutes. So let's start with the first one: terms that are implied by the courts. terms implied by the courts. So you would find that there are instances where the parties might have disagreements with respect to the contractual terms, right? And they go to court. And the court, has the question, the court has now the responsibility to decide whether this is a term or not, or whether this should form a term or not. So the courts, in some cases, can read certain terms, can imply certain terms into a contract, can read certain terms into a contract. But it's important that I state that the courts are usually reluctant to imply terms into a contract because of, the fact that, there's party autonomy. Parties are expected to be able to take care of their own agreements on their own interest. So the court is usually reluctant to imply terms into a contract. But there are instances where the court has to imply terms into the contract. And for the court to be able to imply terms into a contract, it adopts two types of tests: the officials bystander test and the business efficacy test. So as I said, the courts are usually reluctant to get into people's business, to go and be implying and adding terms into agreements that do not really concern them. The business of the court is to enforce the contract, not to write the contract for the parties or to even rewrite it. But there are very little or very small instances where the courts have implied terms into a contract. One of them, for the court to be able to do that, it uses two types of tests: the officials bystander test and the business efficacy test. So what does this even mean? The officials bystander test is that the courts will ask themselves, that if an officials bystander is someone that is just going about his business, right? But remember that this officials bystander is not a real person, it's an imaginary person. So the court will ask itself, if an officials bystander is asked, should we read so and so term into a contract? Would the officials bystander say, of course? Or will the officials bystander say, well, not really? The court will ask, if we ask an officials bystander, that do you think that the parties would have read this particular term into a contract, right? If the officials bystander says, of course, yes, then of course the court will go ahead and read that term into a contract. If the officials bystander would say, not really, then the court would not read it into a contract. Let me give you a better example to help you understand this more. If, this scenario I keep giving you, we walk into a restaurant, right? And you ask for food. You ask for rice, a plate of rice, and dodo, and all the assorted meats, right? Goat meat, cow, chicken, egg, and they put all that in your plate and give you the food. You formed the contract. What are the terms of this contract now? The terms are the fact that you want rice, that you want meat, chicken, goat meat, cow, beef, right? These are the terms. These are the things that you have agreed upon, you and the other party, the seller and the buyer and the seller. You even agreed on the price, that the price at the end of the day is 10,000 naira, right? Those are the terms of the contract. Those are the terms that you guys agreed expressly on, either in writing or by spoken words, right? However, when you ate the food, there was lots of sand in it, right? Or when you ate the food, you took the first spoon and you realized that this food is rotten, this food is spoiled. And you tell the seller, how do you sell such rotten food and expect me to pay for it? And the seller says, did we agree that I will sell you fresh food? In the terms that we agreed upon, was fresh food ever stated there? Or was stoneless food ever stated, or sandless food ever stated there? There is no such term in the contract that we entered into now. I never said anything about it. You never said anything about it. And they go to court, right? And the court decides that, well, we have decided very reluctantly to decide on whether to read the term that the food should be fresh into the contract, even though both of you did not have the sense to put it in your contract. The court has decided, okay, let's see if we should even read it into your contract. Well, let's see if we can imply it into your contract or infer it into your contract. And the court decides to use the officials bystander test. And as is an officials bystander, an imaginary one, remember, not a real one, acts as an officials bystander. Do you think that the parties would have put the term in their contract that the food should be fresh and that the food should not be filled with stones into their contract if they had thought about it? If the officials bystander would say, of course, yes, then the court will go ahead and, read into that contract that the parties, that it is implied that the parties, expects that the food should be stone-free, sand-free, fresh. I hope that's clear enough. So the officials bystander test is where the court asks is, would the parties have read this contract into their terms if they had the opportunity to consider it, right? If the answer is of course yes, then the court will read it. If the answer is no, then the court would not read it. Then the second type of test is the business efficacy test. And what the business efficacy test simply means is that, please mute yourself. Okay, so what the business efficacy test really means is that the aim of the court, before a court would read a term into a contract, the court could also ask itself, would it provide business efficacy in this contract, right? Would it make it more efficient? Would it make it possible for the parties to be able to perform the contract if we read this term into the contract? Let me give you an example. You enter into a contract with your mechanic, and expressly you guys agree that, see, my car broke down on Third Mainland Bridge. I want you to go to Third Mainland Bridge and to go and fix the car, right? And my driver will bring it back home. And I will pay you so and so amount of money. And you, on the other hand, please just a minute. Okay, sorry for that. So the business efficacy test, I was given an example or a scenario of, how the courts usually apply the business efficacy test. So I was saying that the parties have agreed that the mechanic would go to Third Mainland Bridge, fix the car, and my driver would drive it back. And I would pay the mechanic for maybe his transportation to Third Mainland Bridge, the car parts that he needs to be able to fix the car, and his workmanship, right? Those are the express terms that have been agreed between I and the mechanic. But when the mechanic got there, he realized that the problem with the car is the type that cannot be fixed right there at on Third Mainland Bridge. He needs to take it to his workshop. He needs to tow it to his workshop, right, to be able to fix it. And he reaches out to me and says that, see, you need to pay for towing because I can't fix this car here. I can't be able to perform the contract that we both entered into, right? Because when we were entering into this contract, we did not agree on the term that I would tow this car, right? But now, to be able to perform my part of the contract, to be able to do what it is that I agreed to do, I need to tow it. And I say, no, you can't tow it. And even if you want to tow it at your own expense. And the mechanic says, well, and goes to court, right? And the court has to now determine whether to add an extra term to that contract. Of course, the court would acknowledge the fact that there are terms that we expressly agreed upon, But now, should they read some more terms into the contract? And the court decides, okay, let's see if we can read it. And the court decides to look or to use the business efficacy test. In such a case, the court might say, or the court would most likely say yes, to be able to perform this contract, to be able to perform your own part, my own part, for the mechanic to be able to perform his own part of the contract, it's important that the court reads into that contract that the car must be towed to the mechanic's workshop and I would pay for towing. And so that is an example of business efficacy test. It doesn't have to be with respect to towing and this scenario I've given you. This scenario I've just given you is an example of ways that this business efficacy test can be applied, right? So the aim of the court is not just to add terms into people's already formed contracts. The court usually tries to only add terms that it feels are beneficial, terms that the parties would have agreed upon if they had thought about it. Example, officials bystander test and the business efficacy test, would it make the contract easier, more efficient, or even doable in the first place or not? So that is for terms implied by the courts. The next one is terms implied by custom and usage. So you would find that there are times when, there are certain terms which the parties did not expressly agree upon, but they form part of the contract because that particular thing or that particular term is recognized, is notorious, is being recognized, is not repugnant to natural justice, right? And the parties, in that industry are aware that such terms will usually apply to their contracts. For instance, when it has to do with shipping contracts, there are terms which, due to the industry, trade usage, those terms automatically form part of the contract. Let me give you one that you might even be able to relate with. The fact that when you enter into a contract to buy and sell or to lease a house, you would usually find that it has become the custom that agency would be paid. So even though the parties in some cases did not agree specifically, expressly, by words, either written or oral words, that agency would be paid, the court might read such a term into the contract simply because that has been done over time, that it has become a custom in that industry. And so it's notorious, it doesn't go against natural justice, right? So the court might read it simply because, that particular way of transacting has been done over time, that it has become a custom and it's notorious. Everyone knows, it doesn't need to be said, right? And so the court might be able to imply such a term based on custom and usage. Then the next one is terms implied by statutes. Terms implied by statutes. So when we talk about statutes, what does that mean? Statute simply means written laws, right? Statutes usually mean written laws. So you would find that there are actually some laws that have provisions that read terms, that provide that certain terms must form part of the contract. Example, the Federal Competition and Consumer Protection Act has provisions with respect to implied terms. There are provisions there in that act that says that, parties in this contract, these are the terms that would be read into that contract, whether the parties agreed upon them or not. The same thing applies with the Sale of Goods Act, right? There are terms, there are provisions, especially in section 12 to section 15 of the Sale of Goods Act, that implies certain terms into a contract. So even though the parties may not have expressly agreed upon those terms, you would still find that some of those terms will still govern the contract. For instance, Section 12 of the Sale of Goods Act states that there is an implied condition as to title, right? So these are just some of the lists of implied terms that you find in the Sale of Goods Act. These provisions are quite similar to what you would find in the FCCPC. In the FCCPA, that's the Federal Competition and Consumer Protection Act, right? They are very similar to what you'd find. And also the Hire Purchase Act and numerous other acts have very similar, provisions with respect to contracts, right? And so we would just focus on the Sale of Goods Act. So the Sale of Goods Act has a provision, especially in Section 12, with respect to implied condition as to title. It has also implied warranty as to title. It has sale by sample, provisions with respect to sale by sample, sale by description, and implied condition as to fitness and quality. So we'll take this one after the other to be able to understand how statutes can imply terms into a contract. So the first one is Section 12 of the Sale of Goods Act. It implies that sellers, that the seller has, it implies, the provision says that, a seller must have title, must have good title, because you can't sell what you don't have. If you don't have the right to the property, you can't sell it. So when we talk about title, it's not Mr. and Mrs., it's not professor, it's not doctor. The title that we're talking about is with respect to the property. Do you have good title? Do you have ownership? Are you the owner of that, of that property that you're trying to sell? If you are not the owner, then there is an implied condition, that you must be the owner, that you must have good title. What that means is that if parties enter into a contract and it turns out that the seller does not have good title, right? The seller is not the owner of the property. Maybe the seller is also borrowing it, or somehow, the seller is not the owner of the property. There is an implied condition with respect to that. And you know that we've talked about conditions, right? Conditions are those important terms that it entitles the innocent party to repudiate the contract. So it is an important term that parties must only sell what they have. So in other words, the seller, must either own the property or have authority to transfer ownership. So what this simply means is that also, the party, if he doesn't own it, right, it turns out that he doesn't own it, the other party, the innocent party, can terminate that contract and ask for his money back and also ask for damages. So even though the parties in their contract, when they were negotiating, they did not have any term in that contract that you must be the owner of this property, you must have the authority to sell this property, right? Or to sell this thing, right? Even though the parties did not expressly agree upon it, Section 12 has read it into that contract, has forced it, imputed it into that contract. So even though the parties did not expressly agree, we have a provision or a term with respect to title, it has been read into that contract that there is a promise that you, the seller, has the right to sell. And if you do not have the right to sell, the other party, the innocent party, can terminate the contract and also can ask you for damages. In fact, if you don't have the right to sell, you've breached that contract. Then under implied title, there is also the fact that, there is an implied warranty, that the buyer would be entitled to, the buyer would enjoy quiet possession. And the second one is that the goods are free from undisclosed charges and encumbrances. Let me explain this. With respect to quiet possession, when parties enter into a contract, there is a presumption. In fact, the term is read into the contract. But in this case, with respect to quiet possession, you know, it's the warranty. It's not a condition. The one with respect to ownership and title is a condition. The one with respect to possession and encumbrances, free from encumbrances, those ones are warranties. So you know the difference between conditions and warranties. In other words, if a party breaches these ones that are warranties, it doesn't entitle the innocent party to terminate the contract. Rather, it only entitles them to damages. So this part on warranties, I listed 1 and 2 here. I will redo it so that it can be clearer that it's with respect to warranties. This part simply says that if I buy property, I must be able to have quiet possession of it. I must be able to enjoy quiet possession of it. It's not that I will be using it and people that you're owing will be coming to disturb my enjoyment of the property that I've bought from you. So even though we didn't put it in the contract that I must have I must enjoy quiet possession, is read into that contract by virtue of Section 12 of the Sale of Goods Act. So example, if before selling something, right, you did not pay custom duties, right? And each time I drive a car that I bought from you, police, custom keep harassing me. They keep, stopping me from enjoying using that particular car, or even there was even a case where somebody leased a machine. The aim of that machine is to spray, I think it was to spray, is to spray the road. You know those lines that we have in the middle of the road. And so it turns out that, it turns out that he didn't have a right to sell. And so the party who bought that machine was being disturbed. He wasn't allowed to use the machine, as the person who bought it, as someone who now has ownership of it, or someone who leased it, right? So that is depriving the other party of quiet possession. For instance, in a property where I have already leased it, and every day somebody is coming to harass me with respect to that property. The same rule applies, is very similar to the second one, which says that the goods must be free from undisclosed charges or encumbrances. It means that if there is some sort of loan that you've collected and that you've used the property as surety, you have the duty to inform the buyer before buying, before the contract was entered into. And so if you didn't inform them, there are undisclosed charges or encumbrances on the property, then you can be held to have breached these implied terms. The next one is that, is with respect to implied terms with respect to description. So what this simply means is that Section 13 of the Sale of Goods Act provides that that where goods are sold by description, there is an implied condition that the goods will correspond exactly with the description. So the next question I would have expected that you would ask, especially if we were in a physical class, is that what is considered goods that are sold by description, right? Goods that are sold by descriptions are those goods that when the buyer bought them or when the buyer was buying them, the buyer did not have the opportunity to see the physical goods or to touch it or to for instance, the way you go to the market to buy pen, and before you buy the pen, you look at it, you open it up and you even write on a paper to make sure that it actually writes, that is not blocked. Or when you go to buy bulb and they test it for you there in the shop, right? Or even when you go to buy gari, you can pick it up, you can throw it in your mouth and taste it and see if it's fresh and see if it's what you want, right? When you buy those things, that's you buying in the market, right? You can feel those goods, you can see the goods, you can decide whether you want to buy or not buy based on the fact that you've used your senses to be able to determine how good these goods are, So sale by description are those goods that you bought without, using your senses. The only thing that you used in determining whether you would buy or not to buy is the fact that the seller said provided the description with respect to the goods. And that description could be like in a picture, right? The seller showed you a picture, right? Told you that these goods are like this, this color, that color. For instance, I would say that goods sold by description is like when you buy something online, right? You can't taste it, you can't touch it, you can only see the picture that's been provided by the seller. And so your transactional decision is simply based on what the seller has described. So you would find that there are so many instances of what I ordered and what I received or what I got. A lot of people have said that they bought something from Temu, they bought a fridge or a freezer from Temu to now realize that it's not a proper freezer. It's a decoration. It's something that you can place on your table or on your shelf as a decoration. It's a small miniature toy, right? Because you did not see it with your eyes. You only saw the picture that was provided for you. You did not touch it. You did not feel it. You didn't see the size, right? The only thing that you used in making that decision was the picture that was provided by the seller. And maybe the picture was even taken in a way that it made it to look like it's supposed to be big, right? Big enough to be like a standing freezer or a standing fridge, right? And not a miniature toy. So you see that when the goods are sold by description, there is a special protection that is provided by the Sale of Goods Act under this section 13, which says that when goods are sold by description, the goods must correspond exactly with the description. If they do not correspond with the description, then it is an implied condition. The other party can terminate the contract. So in addition, there is also, let me talk about sample, which is very close to description. So there is also section 15 of the Sale of Goods Act, which provides that goods must correspond with the sample when they are sold by sample. So what does it mean for goods to be sold by sample? I'm sure you've seen instances where you go to a vendor or you go to a seller to buy t-shirts, maybe customized t-shirts, right? And they tell you that this is what the t-shirts would look like. This is a sample of what we sell, right? This is a sample of what we sell. And this is exactly what we're going to be supplying to you. In such a case, that will be considered goods that are sold by sample. And so the law says that when goods are sold by sample, the ones that are eventually delivered must correspond with the sample with which the goods were used as being sold, right? So there is an implied condition that if I buy something by sample, then they must correspond with the sample. You can now supply something that is of a lesser quality to me, because what you showed me as a sample was a higher quality. And the goods that you're supplying must correspond with the sample. So what this simply means is that even if it wasn't added into the contract expressly by the parties, right, the courts can read such a term into the contract because the law provides so. The provision also says that, when bulk goods are sold by sample, they must correspond with the quality, yes? 2, the buyer must be given reasonable opportunity to compare the bulk of the goods with the sample that was provided, right? And the goods must also be free from any defects, which are not very obvious on the body of it. If there were defects on the sample, on the body of the sample, it's expected that the buyer would have seen the defects and would have probably negotiated based on the defects, right? But if the defects are the type that they're not obvious from the body of the sample, then it's expected the courts would, in fact, the provision provides that such a defect, it entitles the other party to terminate that contract.
You get it. You get it. The mic is on. I don't think. I don't think. I didn't hear you. Do you hear me? I mean, I don't come class.
Hello, ma, I think you are mute.
I mean, I remind you. My pastor, I remind you.
Sorry about that. I was logged out very briefly. So I would reshare, but this is like the last slide. So the class is almost over. So where goods, so there is the implied condition. There is the implied condition as to fitness and purpose. So what this general rule, before we talk about what the general rule is, right? Before we talk about what implied condition as to fitness and purpose really means, it's important that I state to you that, that there is the general contract law doctrine of caveat emptor, buyers beware. I'm sure you've seen that on buildings. So what it's trying to tell you is that as a buyer, you have the responsibility to do due diligence. You have the responsibility. You have the responsibility to inspect the goods that you are buying, or the services that you're asking for, and to make decisions that are best for your in your interest, right? And that if when you make the right decision or the wrong decision, it's your business. You have the responsibility to do your due diligence. So based on this general rule, the aim of the court is not simply to protect you. Why is this thing not showing? So based on this, the aim of the court is not simply to state, to protect you from making bad decisions. However, Section 14 provides that irrespective of the buyer beware, the caveat emptor. Please, everyone, mute yourself. Someone's microphone is on. There is the provision, there is the implied term with respect to quality and fitness. There is the implied term that goods must have a satisfactory quality, right? Which means that, you know, goods must have good quality. It doesn't have to be the best quality. It doesn't have to be, you know, tear rubber, but that they must have satisfactory quality. They must have good, you know, acceptable quality, right? And of course, that is also another thing that is subjective. Is also, you know, it's there's no hard and fast rule what is acceptable quality or what is not, right? But if such a case comes before the court might be able to determine whether a quality is acceptable or not. But there is this implied condition, you know, that goods must be of acceptable or merchantable quality, and that the goods must be fit for purpose, right? But for a party to be able to rely on this provision that goods must be fit for the purpose for which that they are being bought for, you know, there are certain things that the party must show. One, the party must show that the buyer, you know, informed the seller of the specific purpose that he needs the goods for, or that she needs the goods for, right? And that buyer relied on the skills and the judgment of the seller when buying the goods. So let me explain this, right? The general rule is that there is caveat emptor. Buyers beware. It's expected that if you go to the market to buy flour, you know the flour that is used for baking, or to even buy tomatoes, right? There is caveat emptor. You are supposed to do your due diligence, make sure that the goods are fit for the purpose that you need them for, that the goods are of acceptable quality, and that they fit the purpose that you need them for. But there are instances, there are very little instances where, you know, where the courts or where the law might read, you know, term that the goods should be of good quality into the contract. And one is where the buyer informed the seller or, you know, the vendor that this is the purpose for which I am buying the goods. And then that buyer still went ahead to rely on the expertise, on the skills and the judgment of the seller. For instance, you go to buy tomatoes, right? You remember, if you cook, you know that there are certain tomatoes you can't use to make omelets or to make to fry egg, right? Because you need the very hard ones to fry egg, right? And you did not inform the seller why you need the tomatoes. You can't go back to the courts and sue the seller for selling tomatoes that are not exactly for the purpose that you need it for. Except you can show that you informed the seller that this is what you need it for, and you relied on the seller's judgment. Let me give you another example. You go to buy shoes. You know that there are running shoes and there are shoes that you use for, and there are casual shoes, right? Or even formal shoes. But the one you need are running shoes, the ones that are lightweight, right? And that will protect your ankle while you're on your knee while you run, right? But you didn't tell the buyer, the seller, of the specific purpose that you need it for, right? In a case where you didn't sell that seller, you didn't rely on the seller's opinion. Even if you told the seller, this is what I need running shoes for running, right? But you didn't rely on the seller's opinion. You still went ahead to buy what it is that you wanted to buy. The seller said buy this. You said you still went ahead and bought something else. You can't rely on this implied condition, right? But if you told the seller of the specific purpose that you need it for, and you went ahead, the seller said, okay, these shoes are running shoes, you can buy these ones, right? And you went ahead to do that, then it turns out that the shoes are not running shoes, they're too heavy. Then you can sue the seller for breaching an implied term with respect to fitness and purpose. Let me give you another example, right? You know, these fans, the regular fan, not even holding this fan, right? The regular fans that blow air. And these days we have the AC fans that blow steam, kind of steam. Will I call it? No, not steam. They blow vapor, water vapor, right? They're AC fans, so they're cool. They don't blow out air, right? But then I decide that I have so much money and I want to entertain my children with the most frivolous things. And my children like to stand in front of the fan and sing, and when they sing, their voice shakes, right? And I decided I want that fan to be able to give it to my child to be able to sing in front of it and their voice will shake. And I go to the store to buy, and I tell the seller, this is what I need the fan. No, I need the one that will bring out air, not the one that will bring out vapor. I need the one that will bring out air so that when my child sings, right, their voice would shake due to the air, right? And I rely on that sellers, and he says, no, buy this one, don't buy that one, or buy the other one. And I rely on their expertise and their judgment, and it turns out that it's not fit for the purpose I need it for, then I can bring an action. I don't know if that is clear. Okay, I think that is that for this class. Does anyone have any question? This one, you all are very quiet. I hope that by the next class that we have physically, it won't turn out that you were not listening. You just turned on your phones and went your way. Any question for me?
No,
Okay.
No, ma.
Okay. Let me see, what time is it? So 30 more minutes. We have exclusion clauses, but I don't know if I have slides for exclusion clauses. I didn't put slides for exclusion clauses. Okay, so I'll leave that out. So since there is no question, we'll call it a day. During your next class, another lecturer would come in for capacity and the other topics. But I will share my slides with you, the slides that I've been using for the classes that we've had from the very beginning of the class, with the class rep, and he would share it with you. All the best. Have a great day.
Thank you, ma.
Thank you, ma. I'm sorry, ma. Are we going to get the slide for the exclusion contract? I think you mentioned that now.
No, I won't give you slides for exclusion clause. If I give you slides for exclusion clause, I'll ask you questions on exclusion clause in exam.
All right, ma.
Abi,
Thank you, ma.
Okay, ma, don't give
Abi,
us,
you
ma.
want it? Huh?
Okay, ma,
Don't give us,
ma.
ma.
Oh, ma, this
Don't
one
want
is
it, ma.
enough. Enough.
Don't,
Of this slide that we used to.
don't give us, ma. Thank you, ma.
Okay.
You are not
I'm
a
being
lawyer.
generous and you're saying you don't
Out
want.
of the slide.
All right. I'll miss you all too. Thank you. Bye.
Bye.
You are
Thank you.
Ma, when will the slides of today be
We
ready?
miss you so much. Ma, what about attendance? Please take attendance seriously.
So today there is no attendance. And besides, if I need the attendance, I'll take it from the names of the people that joined the class and also on YouTube.
Okay, ma. Thank you so much. Goodbye.
All right.